Madam Clerk, if you would be so kind as to call the next case, please.
State of Tennessee versus Terrance Williams.
Mr. Green, good morning, sir.
Good morning.
Do you wish to reserve any rebuttal time?
I'd like to reserve 3 minutes, please.
3 minutes. Yes, sir.
May it please the court, my name is Gerald Green from Shelby County. I'm here today to appeal the conviction in State versus Terrance Williams. I think General May had a good tactic in appellate advocacy. He diminished my issues and kind of used it as a red herring to pull you off the road I'm trying to travel. My 3 issues were condensed into, oh, that's a sufficiency of the evidence argument. Well, we know from State versus Pugh and other cases what the standard of review on sufficiency claims is. So if we, to use a term Judge Summers used to use, if we parse my issues down, I have 3 distinct issues. It really come to how far can we cast the net of conspiracy and whether or not there can be criminal responsibility without any foreseeability, to borrow a term from the civil side. Now here we have a man that was in jail. He had been beaten up by one of the guards. He was talking to his sister and he said, but I want to put a scare in him. Well, his nephew, the sister's son, sees the deputy jailer on the street one day and shoots into his car. There's no proof of any communication between the actor and my client, Terrance Williams, and so certainly there's no evidence of any agreement. There's no proof of any direction to the sister or the nephew. There's no proof of how any scare was to be consummated.
Well, maybe I'm confused.
Testimony in the record. I beg your pardon.
I may be confused, but I thought there were some statements made by your client to Tyrone Williams. That's the nephew, correct, Tyrone?
Yes.
About put some fear in him?
That was made to the sister.
That was made to the
Tyrone's
sister.
mother.
Okay.
So he never had any conversation with Tyrone.
Well, but didn't he tell the mother something along the lines of, tell Tyrone this and he can have my car? Something along the, I mean,
Yeah,
I'm not disagreeing with you based on the briefs that he didn't have any direct contact with the other individual, but it does seem that he sent messages through the mother directing the nephew what to do and made a promise to him, if you do it, you can get something in return.
I do not remember that specifically about statements through the mother to the nephew. I do remember that in the record it says that the aunt said, I thought he wanted him beat up. And Tyrone testified he never talked to as you say, he never talked to his uncle. It kind of brings to mind the old Gail Owens case. She wanted her husband killed, but she didn't want him bludgeoned to death. So there was a difference in killing by depravity and shooting. The court made a distinction in that. But as I say, how wide can we cast that net of a conspiracy? They must act with all the actors must be acting with the same culpable intent, that an unlawful act will be carried out. As to the elements of the offenses, possession of a firearm, you had to possess. There was no actual or constructive possession by my client. This seems to be an act of vengeance carried out by a nephew on behalf of his uncle, but not at his direction, or did he have any foreseeability that it would happen in that way? In the employment of a firearm during a felony, got to have intent, knowledge, recklessness for the mental state. And as I say, that possession and employment, they contain the same elements. And then, as I say, the conspiracy definition. As I say, it was vengeance by a nephew for the beating of an uncle while he was in jail. There's no, as I say, for the conspiracy, there is no proof of any agreement between any of the actor or the others involved. I think that perhaps this is a case that probably should have been proof granted at the close of the state's proof, probably to dismiss it, or at least to consider some other charges. In most, if there was an attempt to commit murder, I think that all the proof showed it was an attempt at an assault, an attempt at maybe aggravated assault. But I would ask that the court certainly reverse the convictions in these cases, or send it back to Shelby County, resentencing or other actions. Are there any questions?
Any questions? Thank you, sir.
Thank you.
General May.
May it please the court, Kirby May on behalf of the state of Tennessee. We're asking this court to affirm the verdict of the trial court and the jury.
Do I read, and of course you understand we haven't looked at the transcripts yet on this. I should have looked at the judgment. Was he convicted of conspiracy to commit all of these offenses? First-degree murder, attempted first-degree murder, and employing a firearm? Was it attempt or a conspiracy on all of those?
Under the indictment, he was indicted for conspiracy to commit first-degree murder.
Okay.
Then he had additional counts of criminal attempt, first-degree murder, and employing a firearm as in regards to the criminal attempt, first-degree murder. Those were counts too. Those were under the theory of criminal responsibility.
Okay.
And this is a case where I think Mr. Green was very rightly said that there had been testimony in this matter about an ongoing dispute between the jailer Davis and the defendant, Mr. Williams. And this culminated on August 20th, 2020, with a physical altercation in the jail, in the nursing area of the jail that was observed by a witness, the jail nurse who testified at trial. After that, this is all on the same day, not to be confused. It all occurred the same day within hours. Within moments of that, Mr. Williams, the defendant, made 2 jail phone calls over a period of about an hour or so to Stephanie Williams, his sister. And in those 2 jail phone calls, he very explicitly instructed her to have Tyrone handle this issue immediately and throw a party and go hard, and even gave the victim's numerical address in these jail phone calls. And then, excusing and skipping the expletive, he said, let blank, you know what I'm saying. Go federal. And these are all in these 2 phone calls. And through the course of the trial, you actually had his 2 co-defendants, who were both indicted, Stephanie Williams and Tyrone Williams, testify against the defendant. They testified about their knowledge of the ongoing issues that the defendant had with the deputy jailer. And they were also testified that they were aware of what he was asking. Now, Mrs. Williams did testify she only thought that he was wanted to have Tyrone put fear into the deputy jailer. And she testified that after receiving that second phone call, and he was very emphatic after the first phone call, and it's Exhibit 2, and they're not lengthy phone calls, that he was emphatic and frustrated that she had not told Tyrone before his second phone call. And it was not until after the second phone call that she testified that she called and notified Tyrone of the situation and told Tyrone to handle it. And then you had the testimony of Tyrone Williams, the son, her son, who testified that he understood his instructions and that he intended to kill the deputy jailer. That was his testimony at trial. And looking at the conspiracy, you have to look at as the court is aware, you have to look at the culpable mental state required and the conscious objective. Terrance Williams was very conscious and very emphatic in his direction to what was to happen. And then that he was acting with a purpose and that he was facilitating. He was directing this. And then there was an agreement of one or more of the people. And there's not a direct contact at that day, at that time, between Terrance Williams and Tyrone Williams, but you have the middleman, as I call her, Stephanie Williams. And then all of this is proven circumstantially, but you also have the jail phone calls, the nurse that identify the defendant as the person, as well as the physical evidence from the scene that identified Tyrone Williams with the car and the firearm and things like that. And in the end, one of the most critical things, Tyrone Williams testified that he did receive, even if that Terrance Williams fulfilled the instructions and his agreement and his obligation that he would give Tyrone Williams his car, and Tyrone Williams testified he did receive the car. So that circumstantially shows that his intent and his approval of the actions that day. And then looking at the criminal responsibility, Mr. Green notes, and the state does not dispute that Terrance Williams, while he was in custody, did not possess the firearm that was used to shoot Deputy Jailer Davis. However, those actions were the natural and probable consequences of his instructions.
So him using a firearm, how is that the natural and probable consequence of me telling someone to go handle something? Which at least one witness said, put him in fear, beat him up, whatever you want to say. How is him possessing a firearm a natural and probable consequence of that?
From the circumstantial evidence, if you look at the exact instructions he gave, handle it, throw a party for him, go hard, let him know you know what I'm saying, go federal. Circumstantially, you look at the proof that was presented in the jury's verdict in this situation.
Yeah, but I mean, all those slang terms, I don't know if that means take a gun, shoot him.
Well,
It just means scare him. It means get retribution for him, roughing me up in prison. So to Mr. Green's question, I mean, how far do we cast this net that anything that a co-conspirator or whatever does just automatically falls under this theory of criminal responsibility when there's no proof that he ever told him to use a gun?
Well, this goes to the example that we often give in jury trials to juries when we're talking about voir dire, and you're looking at the bank robbery, and everybody agreed that we're taking the money, and 3 people go in, and one flashes a gun, and one gets the itchy trigger finger and shoots.
That's different. That's different. I know when I'm walking in with my fellow bank robbers that they're armed, and you're right. There's a natural probable consequence. One of them may get an itchy trigger finger and shoot someone. Here, all he did was say, handle this. He didn't say, go shoot his car up. He didn't say use a gun. He just said, go handle it. How is he supposed to know that he's going to use a gun? He didn't direct him to use a gun.
Not in so many words, no, Your Honor.
Okay, so how is he in possession of a gun?
But you also have to take in circumstance the conversations that Tyrone Williams testified to they had previous to this, and that his understanding of the intent that he was being instructed to do. Tyrone Williams is very explicit that he understood his instructions were to kill him.
So there's evidence in the record that Mr. Tyrone Williams testified that they had other conversations?
Not that day. that he was, when he was testifying at trial, the testimony discussed generally that his awareness of the ongoing dispute between Deputy Jailer and that his frustrations, and it is also clear from those jail phone calls that the information about the victim's address had been previously given, because that's not given in this. And the record's clear that Tyrone Williams went looking to the victim's address and then found the victim driving in that direction to his home. And so that circumstantially, yes, and the evidence in a trial like this is taken in the light most favorable to the state. And that's what's, and looking at the testimony from the witnesses that testify in regards to that and their
So if
laws.
Tyrone Williams had taken something out of the victim's car after shooting him, is this defendant guilty of the theft as well? I mean, because under your argument, that's just a natural and probable consequence of him committing a crime for the guy.
Well, that wouldn't, well,
Don't
that would
you-
take a second step on the direction of, his direction was to go hard.
Okay.
To let him know. It wasn't, and
When you-
also take.
I guess my point is, when you can show me his direction was shoot at him with a gun, then you got a better argument for your criminal responsibility, but you don't have that.
No, we
But
have.
under your argument, because he makes some general statement, some slang statement, I could argue just as easily that if he took a cell phone out of the car after he shot him, well, he told him to go hard and make a statement, so he also stole his phone. Okay, you're guilty of theft?
Well, it's similar to the situation where if Tyrone Williams had shot up the car and there'd been a passenger in the car. Would he have been responsible for that? And the likelihood, in the history of this, in the state and the opinions here, that likelihood would have been.
Will we find any proof in the record that the defendant was aware that Tyrone Williams had possessed a firearm or previously used a firearm under violent circumstances?
No, I do not believe so, in my memory of the record. I'd say I'd have to go back and look at that, but I do not believe that there was discussion about him providing Tyrone Williams a gun or of that, but I'd have to go back and look at the record as to that. It's been a while. If y'all have no other further questions, I'd ask this court to affirm the verdict as charged.
Thank you, sir.
Thank you for your time.
Mr. May, I believe you have all your rebuttal time. I'm sorry, Mr. Green. That's all right. I'm kind of a rookie at this.
You won't be next year.
Yeah, I think if you look at the case of State versus Patel, in conspiracy and criminal responsibility, there must be an agreement to have a specific intent that a crime be committed. So I would ask the court, certainly based on Mr. May's arguments that he admits that there was never any possession. He says that there had been prior conversations, but we don't know when those conversations were. They're not in the record that what he wanted done. But as he said, these directions and the occurrence of the beating that the nurse observed all happened within a short period of time, the same day. So I would ask the court to, and there's no testimony as to any directions, as the court pointed out. And sometimes people don't understand what we say sometimes, Mr. May says to his understanding. Well, I didn't say it, I didn't intimate it, and I would ask the court to reverse the trial court.
Mr. Green, just a quick question. This
Yes, sir.
term, "go federal,"
You know,
was there any explanation given, or did the parties even argue what that particular term meant?
I don't have any recollection in the record of anybody discussing what that meant, and I certainly, of all my years practicing and listening to slang, I don't know what that means either. Thank you.
Any other questions? Thank you, Mr. Green.
Thank you, sir.
Madam Clerk, please call the last case on the morning docket.
State of Tennessee versus Marlos Lakeith Tipton.